The air in Courtroom 5 of the San Francisco Federal Building was thick with anticipation, the kind that makes even seasoned attorneys shift in their seats. It was supposed to be a routine hearing, a procedural stop on the endless conveyor belt of federal litigation. But as the clock ticked toward 9 a.m., it was clear to everyone present that this morning would be anything but ordinary. The gallery was packed. Reporters, law students, legal scholars, and a handful of curious citizens, all drawn by the promise of a confrontation between two formidable figures, Judge Edward Chen, a jurist with a reputation for intellectual rigor and little patience for legal missteps, and Representative Jasmine Crockett, a congresswoman from Texas, known for her sharp legal mind and unflappable demeanor, as the bailiff called the court to order. A hush fell over the room. Judge Chen entered, his expression inscrutable, and took his seat behind the imposing mahogany bench. He adjusted his glasses, glanced at the docket, and then fixed his gaze on the plaintiff's table, where Representative Crockett sat alone, her legal team conspicuously absent. It was a bold move, one that had already sparked debate in legal circles. Why would a sitting member of Congress choose to argue her own motion, especially in a case with such high stakes? Some whispered that it was political theater, a calculated risk to boost her profile. Others, more familiar with Crockett's career, suspected something deeper, a personal commitment to the cause at hand, and a confidence in her own abilities that bordered on audacious. Judge Chen wasted no time. "Representative Crockett," he began, his tone clipped, "I've reviewed your emergency motion for a temporary restraining order. I must say, I'm struggling to understand how someone with your legal background could submit a filing so fundamentally flawed." He held up the document between two fingers, as if it were something distasteful. "Your motion lacks basic legal foundation. The precedents you've cited are either irrelevant or misconstrued. I expect better from an attorney, let alone a member of Congress." A ripple of discomfort passed through the gallery. Even the most jaded observers recognized the significance of the moment. Judge Chen was not merely questioning the merits of the motion. He was questioning Crockett's competence. For a brief moment, the courtroom seemed to hold its breath, waiting to see how she would respond. Would she retreat, as so many had before, under Chen's withering scrutiny? Or would she rise to the challenge? Crockett stood, her movements deliberate and composed. She approached the podium with a calm that belied the tension in the room. "Your Honor," she began, her voice steady, "I appreciate the court's candor. If I may, I'd like to address your concerns point by point." There was no trace of defensiveness, no hint of the grandstanding some had predicted. Instead, there was a quiet confidence, the kind that comes from knowing you are prepared. Judge Chen arched an eyebrow, clearly expecting a perfunctory defense. "Proceed," he said, his tone still dismissive. Crockett opened a leather-bound folder, revealing a meticulously organized set of notes and legal references. "With respect to your first point, Your Honor, regarding the applicability of Bennett v. Speer, I believe the relevant distinction lies not in the finality doctrine as articulated in that case, but in Justice Scalia's analysis in Whitman v. American Trucking Associations." She paused, allowing the reference to sink in. In Whitman, the court clarified that an agency action may be considered final even when future implementation details remain undetermined, provided the action itself establishes binding norms that immediately affect regulated parties. A murmur ran through the gallery. Judge Chen's expression shifted, ever so slightly, from disdain to curiosity. It was a subtle change, but those who knew him recognized it as a sign that he was listening. "Really listening," Crockett continued, her delivery measured and precise. "Furthermore, the D.C. Circuit expanded on this principle in Coalition for Common Sense in Government Procurement v. United States, a case that, while not controlling in this jurisdiction, offers persuasive reasoning directly relevant to the facts before us." She flipped to a tabbed page in her notes. "I've cited this on page 17 of our brief. Your Honor, the court there held that when an agency action commands immediate compliance and threatens immediate sanctions, it constitutes final action, regardless of how the agency characterizes it." Judge Chen glanced at his own copy of the brief, searching for the citation. The courtroom was silent, the tension now tinged with a sense of anticipation. Crockett was not merely defending her motion. She was systematically dismantling the judge's criticisms, one by one. Turning to your second point. Your Honor, Crockett said, regarding Lincoln v. Vigil, I would respectfully submit that the Supreme Court's holding in that case is often misunderstood. While the court did find that certain agency resource allocations are unreviewable, Justice Souter's opinion specifically distinguished between general program funding decisions and actions that withdraw previously established rights. The latter, as the court made clear, remains subject to judicial review. She paused, then added, if you'll turn to Exhibit C, Your Honor, you'll find the agency's own internal memorandum acknowledging that the directive at issue represents a significant departure from established practice, one that would immediately terminate existing benefit eligibility for the affected populations. Judge Chen looked down at the exhibit, his brow furrowing. For the first time, there was a hint of uncertainty in his demeanor. Crockett pressed on, her voice unwavering. The law is not merely a set of rules, Your Honor. It is a living body of principles shaped by precedent and context. To apply it mechanically is to risk injustice. That is why we cite not only controlling authority, but also persuasive reasoning from other circuits and recent developments in administrative law. The gallery was riveted. Even the court reporter, usually immune to the drama of oral argument, seemed to be hanging on every word. Crockett's performance was not just a defense of her motion, it was a masterclass in legal advocacy. Judge Chen's reputation for intellectual impatience was well-earned. Lawyers who appeared before him knew to come prepared for a grilling, and many left the courtroom with their egos bruised. But as Crockett continued, it became clear that this was not going to be a typical exchange. She was not only prepared, she was anticipating his every move, countering each objection with a citation, each criticism with a carefully chosen precedent. Your Honor, she said, I'd also like to address your concerns regarding the Administrative Procedure Act. The government has argued that the directive in question does not constitute final agency action, and therefore is not subject to judicial review. However, as the Ninth Circuit held in Oregon Natural Desert Association v. U.S. Forest Service, when an agency action commands immediate compliance and threatens immediate sanctions, it is final, regardless of the agency's characterization. This is not a matter of form, but of substance. She paused, letting the point settle. Judge Chen tapped his pen against the bench, a subtle sign that he was processing the argument. The DOJ attorneys at the defense table exchanged uneasy glances. They had come prepared to face a politician, not a legal tactician, with a command of administrative law that rivaled their own. Crockett turned to the equal protection claim. The heart of her motion. Your Honor, even accepting the government's characterization of the directive as a neutral security measure, we must consider the Supreme Court's recent decision in Department of Commerce v. New York. Chief Justice Roberts, writing for the majority, established that even facially, neutral government actions may be subject to heightened scrutiny when there is evidence that the stated rationale is pretextual and the action disproportionately impacts protected groups. Judge Chen interjected. That was the census case. The context was quite different, was it not? Crockett nodded, unfazed. The facts were different, Your Honor, but the legal principle is broadly applicable. The court made clear that when the record reveals a disconnect between the agency's stated rationale and its actual priorities, heightened scrutiny is warranted. In our case, internal agency communications obtained through a Freedom of Information Act request. Exhibits D through G strongly suggest that the security rationale for this directive is pretextual. The impact on minority communities is both immediate and severe. A low murmur rippled through the gallery. The mention of unreleased documents and the suggestion of pretext added a new layer of intrigue. Judge Chen leaned forward, his interest piqued. Mr. Reynolds, he said, turning to the government's lead attorney, does the government wish to respond to the Congresswoman's characterization of these communications? The attorney rose, his confidence visibly shaken. Your Honor, we have not had an opportunity to review all the documents referenced in the plaintiff's exhibits. We would request time too. They were attached to our original filing, Your Honor, Crockett interjected, her tone polite but firm. Exhibits D through G, submitted 5 days ago. The government attorney hesitated, then nodded. We would request a brief recess to confer, Your Honor. Judge Chen agreed, calling a 15-minute recess. As he left the bench, the courtroom erupted in whispered conversations. Reporters scribbled notes, law students exchanged wide-eyed glances, and legal scholars debated the implications of what they had just witnessed. Crockett, meanwhile, returned to her table, composure unbroken. When the court reconvened, the atmosphere had shifted. Judge Chen returned with several additional reference materials, and the government's legal team had been joined by 2 more attorneys. The stakes had clearly escalated. Before we continued, Judge Chen began. I'd like to ask Representative Crockett to elaborate on her application of the Department of Commerce precedent to the equal protection claim. Specifically, how does she reconcile that with the traditional Arlington Heights framework for detecting improper governmental motivation? It was a highly technical question, one that would have rattled even experienced litigators. But Crockett didn't miss a beat. Thank you for that excellent question, Your Honor. The relationship between the Commerce holding and the Arlington Heights framework is precisely the issue I hope to address. Arlington Heights established a multi-factor test for detecting discriminatory intent, including the historical background of the decision, the sequence of events, departures from normal procedure. In legislative or administrative history, she stepped away from her notes, signaling complete command of the material. What makes the Commerce decision significant is that it effectively lowered the evidentiary threshold required to trigger heightened scrutiny when there's evidence of pretext. Chief Justice Roberts wrote, "We are presented with an explanation for agency action that is incongruent with what the record reveals about the agency's priorities and decision-making process. That's standard. Incongruence with the record is a more accessible framework than the traditional Arlington Heights factors, especially in cases involving complex administrative action where discriminatory intent may be carefully concealed." Judge Chen nodded, his skepticism giving way to genuine engagement. But Arlington Heights remains controlling precedent. Absolutely, Your Honor, Crockett replied. I'm not suggesting Commerce replaces Arlington Heights, but rather that it offers a complementary analytical pathway. In Regents of the University of California v. Department of Homeland Security, the DACA case, Justice Roberts again expanded on this concept of pretextual justification. While the holding primarily addressed APA claims, footnote 7 on page 1909 explicitly connected this analysis to equal protection doctrine. She recited the footnote from memory, a feat that drew impressed looks from the gallery. While these considerations are not pertinent to the APA analysis, they would certainly be relevant to an equal protection challenge. Judge Chen's eyebrows rose. Few attorneys would cite a specific footnote from memory during oral argument. Crockett's mastery of the material was undeniable, even accepting your characterization of Commerce and Regents. The judge said, "You still face the challenge of showing that the disparate impact here rises to a level that triggers heightened scrutiny under traditional equal protection analysis." Crockett nodded. "That's where our evidence becomes crucial, Your Honor. If you'll turn to Exhibit E, page 4, you'll see an internal agency memo, explicitly acknowledging that the directive would impact congressional districts with majority-minority populations at a rate approximately 8.7 times higher than districts with majority-white populations. Collective gasp swept through the courtroom. The statistic was damning, and it had not been highlighted in any previous media coverage. Judge Chen's face betrayed a flicker of surprise, the kind that only the most seasoned court observers would catch. He glanced at the memo, then at the government attorneys, who now looked distinctly uncomfortable. Crockett pressed on, her voice unwavering. Her argument building with the momentum of someone who knows the law is on her side. And on page 6 of that same exhibit, Your Honor, the agency's own legal department warned that this disparity raises significant equal protection concerns that could leave the directive vulnerable to constitutional challenge. The agency never conducted the more rigorous impact analysis that its own legal department recommended in that same memorandum. The government's lead attorney, Mr. Reynolds, rose again, this time with less certainty. Your Honor, we would characterize those communications differently. They represent preliminary staff assessments that were ultimately not adopted by agency leadership. Crockett responded without missing a beat. But they were never affirmatively rejected either, were they? And more importantly, the agency never conducted the more rigorous impact analysis that its own legal department recommended in that same memorandum. Under the Supreme Court's holding in Department of Commerce, the court isn't limited to the administrative record when there's evidence suggesting the stated rationale may be pretextual. As Chief Justice Roberts wrote, "We cannot ignore the disconnect between the decision made and the explanation given." Judge Chen nodded slowly, the earlier edge in his tone now replaced by a measured respect. He returned to his initial criticism. "Let's revisit your reliance on Lincoln v. Vigil, which I initially suggested undermined your position. You argued that Justice Souter distinguished between general program funding decisions and actions that withdraw previously established rights. Can you elaborate on that distinction as it applies here?" Crockett's answer was immediate and precise. "Certainly, Your Honor. The key passage appears on page 170 of the opinion, where Justice Souter writes that while agencies have broad discretion in allocating resources, that discretion doesn't extend to actions that withdraw previously established rights to benefits. The court reaffirmed this principle in Weyerhaeuser v. U.S. Fish and Wildlife Service, clarifying that administrative discretion is not unlimited and does not include the authority to violate constitutional or statutory constraints." She paused, then delivered her most powerful argument yet, but perhaps the most directly relevant precedent, one that synthesizes these principles in a context remarkably similar to ours, is one that hasn't been cited yet, because it was only decided by the D.C. Circuit 3 weeks ago. She produced a freshly printed document from her folder. In Center for Biological Diversity v. Office of Management and Budget, the court held that when an agency directive operationally amends a statute by creating categorical exclusions not found in the statutory text itself, such action is reviewable even if framed as a resource allocation decision. The courtroom fell silent. This case was so recent that even Judge Chen, known for his encyclopedic knowledge of federal case law, appeared unfamiliar with it. Crockett handed copies to the clerk, distributed them to the bench and opposing counsel. "While this is persuasive, rather than binding precedent, Your Honor, I believe the court will find Judge Srinivasan's analysis particularly applicable to our situation. The decision makes clear that agencies cannot evade judicial review simply by labeling their actions as resource allocations, when, in fact, they are withdrawing established rights." Judge Chen scanned the document, his expression shifting from curiosity to genuine interest. "Representative Crockett, this is an impressive piece of legal research," he acknowledged. "I'm curious, how did you come across this decision so quickly after its release?" Crockett allowed herself a small, professional smile. "I clerked for Judge Srinivasan before entering private practice. Your Honor, we've maintained a professional correspondence about developments in administrative law. When this case was decided, he mentioned it might have implications beyond environmental policy." A ripple of surprise moved through the gallery. Law students exchanged excited whispers, and even the most jaded reporters seemed to sit up straighter. Crockett had revealed her connection to one of the most respected federal judges in the country, but only after her legal reasoning had already demonstrated her exceptional competence. It was a master stroke of advocacy. Substance first, credentials second. Judge Chen set down the opinion and removed his reading glasses, a gesture that courtroom regulars recognized as signaling a significant moment. "Mr. Reynolds," he said, turning to the government attorney, "the court would benefit from the government's response to this recent precedent. However, it appears you may not have had an opportunity to review it." The DOJ attorney stood, visibly uncomfortable. "That's correct, Your Honor. We would request time to evaluate this case and prepare a response." Judge Chen nodded. "That seems reasonable," turned back to Crockett. "Representative, your legal arguments have raised substantial questions that deserve careful consideration. While I initially expressed skepticism about the foundation of your motion, you have presented precedent, including very recent precedent. that may well be controlling in this matter. A buzz of surprise ran through the courtroom. What had begun as a seemingly routine denial of an emergency motion had transformed into a victory for Crockett. Judge Chen continued, "The court will issue a temporary restraining order, halting implementation of the directive for 14 days, during which time the government will have an opportunity to respond more fully to the arguments and precedents raised today." The gallery erupted in hushed conversations. Reporters rushed for the exits, eager to file stories about the unexpected turn of events. Legal observers who had come expecting to witness a routine denial found themselves discussing a case that would likely appear in law. School textbooks about effective advocacy. Crockett remained composed, her expression professional rather than triumphant. "Thank you, Your Honor. My only aim was to ensure that the court had the benefit of all relevant precedent before ruling on a matter of such significance to my constituents." Judge Chen concluded the hearing and rose from the bench. The courtroom buzzed with a new energy. The day's events had not only changed the course of a single case, they had set a new standard for legal advocacy in the federal courts. The aftermath of the hearing rippled far beyond the walls of Courtroom 5 within hours. Legal blogs and news outlets were abuzz with headlines. Judge Chen, stunned by Crockett's legal mastery. Congresswoman citations turned the tide in federal court, and a new standard for advocacy set in San Francisco. The video of the hearing, posted to the court's public access channel, quickly went viral, amassing millions of views as lawyers, students, and ordinary citizens alike watched the drama unfold. For many, it was a rare glimpse into the inner workings of the justice system, a reminder that even in an era of cynicism and polarization, substance and preparation could still triumph over preconception. In the days that followed, the legal community dissected every moment of the exchange. Law professors assigned the transcript as required reading, pointing to Crockett's performance as a model of composure under pressure and the power of meticulous preparation. Bar associations invited her to speak at conferences, eager to hear firsthand how she had managed to turn a judge's skepticism into respect. Even Judge Chen, known for his reluctance to admit error, was praised for his willingness to reconsider his initial assessment in the face of compelling argument. But the impact of the hearing extended beyond professional circles. For young lawyers and law students, especially those from underrepresented backgrounds, Crockett's victory was more than just a legal triumph. It was a powerful statement about what was possible when expertise met opportunity. Social media lit up with messages of admiration and inspiration. "Watching Representative Crockett in court today made me believe I can do this too," one law student tweeted. Preparation, poise, and the courage to stand your ground. That's what real advocacy looks like. The government, meanwhile, was forced to regroup. Internal reviews revealed that junior attorneys had flagged the Center for Biological Diversity precedent, but their concerns had been dismissed by senior officials as irrelevant. The oversight led to a formal review of the department's case, preparation procedures, with new directives issued to ensure that all relevant legal developments, no matter how recent, were considered in future filings. There's been a tendency to underestimate congressional representatives when they appear as advocates, admitted a senior DOJ official. After what happened in Judge Chen's courtroom, that's going to change. The case also sparked a broader conversation about the role of elected officials in the courtroom. Historically, judges had often viewed politicians who argued cases with a degree of skepticism, assuming their legal skills had atrophied in favor of political rhetoric. Crockett's performance challenged that assumption, demonstrating that a commitment to the law and a willingness to do the hard work of preparation could bridge the gap between politics and legal practice. Media outlets began to highlight the legal backgrounds of lawmakers, and law schools reported a surge in applications from students. Inspired by Crockett's example, perhaps the most lasting impact, however, was the shift in judicial attitudes. In the months following the hearing, federal judges across the country were observed to treat lawmakers who chose to argue legal motions personally with greater respect and openness. The Chen-Crockett exchange became a touchstone in discussions about judicial temperament and the importance of approaching every case with an open mind. At a judicial conference, Judge Chen himself reflected on the experience, noting, "What happened in my courtroom that day was a valuable reminder that we judges should never make assumptions about the legal capabilities of those who appear before us based on their current professional titles." The victory was both personal and professional. She continued to serve her constituents in Congress, but her reputation as a legal advocate soared. Invitations to speak at law schools and legal conferences poured in, and her approach, thorough preparation, calm under pressure, and a focus on substance over showmanship, became known as the Crockett method in legal circles. She remained humble, often reminding young lawyers that in a courtroom, what matters isn't your title. It's your command of the law and your respect for the process. The story of Judge Chen and Representative Crockett became more than just a dramatic courtroom moment. It evolved into a case study in effective advocacy and judicial humility, a reminder that the law is ultimately about the pursuit of justice, not ego or reputation. It showed that even the most entrenched assumptions could be challenged and changed. By the power of reasoned argument and the courage to stand firm in the face of doubt, as the months passed, the case continued to influence legal education and practice. Law schools incorporated the transcript and video into their advocacy courses, and continuing legal education modules were developed to teach the lessons of the Chen-Crockett exchange. The legal community and the public at large were reminded that the pursuit of justice is a living, breathing endeavor, one that demands not only knowledge and skill, but also humility, integrity, and the willingness to listen. And so, the legacy of that day in Courtroom 5 endures. It stands as a testament to what is possible when preparation meets opportunity, when substance overcomes skepticism, and when the law is wielded not as a weapon, but as a tool for truth. In the end, it was not just a victory for Representative Crockett or a lesson for Judge Chen. It was a moment that reaffirmed faith in the legal system itself, a system that, at its best, rewards those who come prepared, who argue with integrity, and who never lose sight of the higher purpose of justice.